I'm Natasha Hausdorff. I'm a barrister and a director of UK Lawyers for Israel. I've been asked to address the Israeli government's current proposals for changes to the administration of certain parts of Area C in the West Bank. Many have spoken of the 1st of July 2020 as a deadline. That date having passed, I was asked for an update and to clarify the position under international law. First, let me clarify that the arrangement provided for in the coalition agreement was to start the discussions of the proposal of applying Israeli civilian law in parts of Area C from the 1st of July. And this is in fact exactly what is currently happening. There are discussions in the Knesset in process on exactly what these proposals should look like. But before we can have any sensible conversation about the proposals, in order to have an informed debate about the pros and the cons, we need to be absolutely clear about a couple of things. Number one, this is not annexation. Annexation is about taking for yourself territory belonging to another state. So it's what Russia did in Crimea in 2014. It's what Germany did with Austria in 1938. And it's what Jordan tried to do in the West Bank between 1948 and 1967. What's being considered here by Israel in Area C does not involve any other state's territory. It is not annexation. And use of the term is wrong, it's sloppy, and unfortunately it's incredibly misleading. Number two, I would say it's not illegal. Contrary to what seems to have become the received wisdom, Israel's proposal to apply Israeli civilian law in Area C is not a violation of international law. Since its independence in 1948, the only state that can be described as sovereign in that territory is Israel, and it's universal, fundamental, customary international law that tells us this. If for some reason the international community is making an exception here with respect to Israel, that is a double standard, and that is the true violation of international law, that out of all of the countries in the world, they would choose to treat Israel differently. So what Israel is considering is a change to the internal administration of the area where it has sovereignty. In that sense, it's not a change to the status of the territory. It's a change to the form of temporary administration, which Israel instituted in 1967, which Israel is fully, lawfully able to do. And it's this rhetoric on international law and this misrepresentation and even abuse of international law, which we've been hearing so much of in the last couple of months, that has been creating so many problems. The administrative regime that Israel established in 1967 in the West Bank was intended to be temporary because it was anticipated, it was hoped by Israel that a negotiated peace agreement at the time with Jordan could be swiftly achieved, and that would bring an end to that temporary administrative arrangement, and it was accepted that it might involve a change to sovereignty and a change to borders as part of a negotiated settlement. 53 years later, there are many in Israel who have contended that it is entirely unreasonable to expect Israel to maintain a situation of limbo, a situation where Knesset legislation does not apply to these areas properly, where there is therefore a devastatingly confusing patchwork of illegal administration, where there's leftover Jordanian law, Ottoman law, British mandate law, and an application of certain aspects of international humanitarian law, but often utter confusion at how this patchwork regulates 21st century issues, where there is a total absence of environmental legislation and the sorts of provisions which benefit the rest of the country where civilian law is applied in full. And I think it's also important to remember that this is a proposal of a democratically elected government that has decided that this temporary administration is no longer sustainable. So, of course, everything that I've said doesn't stop international organizations and governments around the world from indulging in this misrepresentation. Even eminent law professors are joining the herd mentality of everybody says. But everybody says is not international law, it's mob law. Everybody says is how you run a lynch, not a legal system. And this tsunami of slander has engulfed even supporters of Israel, those who understandably perhaps seek the path of least resistance. But if that is at the expense of the truth and the justice of the situation, and the just treatment of Israel in the community of nations, then I think it's the same mistake we have been making every time that Israel is discriminated against in the world, every time that Israel's rights are violated, every time that Israel is smeared and people look the other way. And there is an urgent need to push back on the groupthink, which requires the application of double standards against Israel in international law in an attempt to justify the term annexation in respect of Israel's proposals. Now, it irks me as a lawyer, but really, it should trouble everyone that the international community is content to have a general rule and an exception for the only Jewish state. There is no other state's territory in the equation here. Israel's sovereign claim to the territory since 1948 is rooted in fundamental customary international law, and that is the universally applied principle of uti possidetis juris, which I would encourage everyone with an interest in this to look up. There is this fundamental principle of international law that establishes the borders of newly emerging states at independence, as in Israel's case in 1948. It is universally applied. In the 19th century, it was applied in South America. Later, it was applied in Asia and Africa, and still later, at the disintegration of the former communist federations. It was applied to all of the states that emerged in these cases, and also to states emerging from former mandates. The universal rule for determining the borders of newly emerging states at the moment of independence dictates that a new state takes on the boundaries of the pre-existing unit as its international borders. Now, this is the rule of uti possidetis juris. It is the default. So anywhere there is no agreement to the contrary, this is the universally applied rule as a matter of customary international law. To provide certainty, to avoid frontiers being challenged, to avoid wars breaking out, and to promote peace and stability. Those are the reasons the International Court of Justice recognized as being behind the development of this fundamental principle. Another fundamental principle of international law is its equal application. I alluded to this earlier. You can't have a general rule and an exception for a country you just don't like very much, or you have some political or ideological opposition to. That is not how any respectable legal system can operate. So the question is, what does this principle, universally applied, tell us about the legal status of the territory in Israel's case? Well, in 1948, the administrative lines of the eastern side of the British Mandate ran along the Jordan River all the way to the south, originally dividing it from the separate administrative unit of Transjordan, which became the Hashemite Kingdom of Jordan. Israel, as the only state to emerge from that Mandate territory in 1948, automatically assumes as its international borders the administrative lines of the Mandate, and that includes East Jerusalem and the West Bank, which was occupied by Jordan in 1948 in Israel's independence war. These same areas were then recovered by Israel in 1967. And so this principle of international law must tell us that the legal status of the territory is that Israel has been sovereign since 1948. This is a key reason why the suggestion that Israel is extending sovereignty here is also misconceived, because with respect to the application of this universal principle, these are areas in which Israel is already sovereign. And what we are looking at, as I indicated, is the application of the Israeli civilian law in place of the temporary administrative framework which was originally applied. I was asked about the relationship between legal and moral obligations and arguments that have been made around that relationship. This is where the legal and the moral misrepresentations, if you will, have been going hand in hand. I spoke about what international law says with respect to the application of the principle of uti possidetis juris. It's not correct to say that ordinary Palestinian Arabs who might be impacted by these proposals will necessarily oppose them. because depending, of course, on what proposal is finally implemented, residents of the area stand to gain substantially. And that is with respect to Jewish inhabitants as well as Arab inhabitants, in terms of access to healthcare, access to the welfare system, access to social security benefits, and the right to vote in municipal elections, and other rights that attach to residency, including the possibility of acquiring citizenship and therefore all of the rights and benefits that attach to being a citizen of the only democracy in the Middle East. And so there is an important moral imperative, if you will, behind that sort of analysis. But to address that issue perhaps more directly, I think the point to stress here, and it's a matter of common sense really, it's that the proposal would not prejudice in any way any future negotiations. Any proposals around a two-state solution have envisaged sovereign Israeli territory being transferred via land swaps. Most recently, the Trump plan sees chunks of the Negev, undisputed Israeli sovereign territory, being transferred in that fashion. Israel has negotiated over land to which its law is applied in full. It has shown every intention of continuing to do so. So one issue I think we need to be clear on is that the proposals do not in any way impact future negotiations. They certainly don't provide an impasse to a two-state solution. And the moral arguments that we've been hearing are therefore also based on significant misrepresentations. Not least the argument that this is a violation of international law is used in order to promote a moral analysis and a moral argument, and obviously the central point of our conversation here is to debunk that myth. Part of the difficulty where you mix law and politics in this fashion, especially when it comes to international law, is that most people are not familiar enough with what international law says and are not able necessarily to push back when it is misrepresented or abused in this fashion. And so it really is the rhetoric of international law trumping the reality of it. And I think that feeds into the sort of moral arguments to which you might be referring. I also think that this notion that, the sky is going to fall in if Israel does this, and the sort of warnings that we have been hearing from countries not just in the region, but also from the European Union, and of course from the United Kingdom, so much so that Boris Johnson took the initiative of writing an op-ed in Hebrew in one of the most popular newspapers in Israel. And I think we need to be careful before we accept the doomsday predictions, which have been wrong so many times in the past, and we heard similar warnings over the US recognition of Jerusalem, over the US decision to move its embassy to Jerusalem, over the US recognition of the Golan Heights as sovereign Israeli territory, and none of those predictions materialized. But I think especially when we look to Israel's relationship and the blossoming positive diplomatic relations that it has enjoyed with a number of countries in the Middle East, I think we also need to appreciate that in the Middle East, there is an appreciation of strong countries and an acceptance in that sense of this move on Israel's part being part of Israeli policy, and certainly something which has been mooted for discussion for many decades. It's not a new idea. It's not an idea that has been born out of current American foreign policy. I also think that those Arab states that Israel has a blossoming relationship with appreciate Israel as a strong ally, that it is dependable, perhaps also when they have been let down by others, and the US involvement in the Iran deal was a perfect example of that. The security cooperation, the intelligence sharing that often goes on behind the scenes is incredibly important to these countries. I think it may very well be that there is one message that they send to the world and another message which they may pass far more quietly to Israel. Thank you for listening. I hope this serves to correct some of the misconceptions with regard to Israel's proposals to apply civilian law in parts of Area C.